I appreciate the conversation that we've had, but if I were to think this through, and I definitely appreciate what the city attorney has had to share, but when it comes down to looking at this from two lenses, one is transmittal of a record, and having said and understanding the conversation about and when a judge makes a decision and who is the person or who checks what the judge does in order for some, when it's appealed to the next higher level in a court. Judges are trained as lawyers first, and they also have law clerks who write opinions. I would know that based on the fact that I was one. That's a difference with what we're looking at with the record that we have here. So the BZA, for example, it's a body that's acting as part of the city. And they have a record. And while they have adopted a record, our chair of the BZA actually sent an email I received tonight, and it says the concern stemmed from...
We have that.
Oh, I understand, but I'm reading this for the sake of the public who does not have it and cannot see it. We all know that the city isn't suing its own board, as unfortunately some have said. The state statute says quite clearly that, and I quote, "Any review of a decision of the board shall not be considered an action against the board, and the board," I will not read the whole thing, "shall not be a party to the proceedings. However, the board shall participate in the proceedings to the extent required by this section," and that's Virginia Code section 15.2-2314. It goes on to say that the board shall file a return that, and I quote, "shall concisely set forth such other facts as may be pertinent and material to show the grounds of the decision appealed from, and shall be verified," end quote. Board members were concerned about who decides what is pertinent and material and who will do the verifying. It's never been a problem before, but in my experience, we've never had a case where the city was the one appealing. And it goes on to give kudos to staff, because it says usually we've got a situation where a citizen is unhappy with their decision, and the city attorney's office, in conjunction with the planning staff, has always been the one to respond, and they do fine work. But now that we're looking at this, but I've been told by the folks opposing the city's appeal that they're going to scour the record to see that it's properly complied with or compiled and filed, and I'd hate for them to have some sort of an objection based on the fact. So where I'm going with this is, where do you have a party show up in circuit court, even from the perspective of a pass-through, and not have a person with that legal expertise there with the respondent that is named to do this? I've been in plenty of courts. I understand findings of fact. I understand that both parties, or all parties to actions, submit findings of fact and conclusions of law, and I understand that a decision is made, and hopefully you're going to get some consensus building and stipulation of the facts by all the parties involved. I get that fact. I can appreciate everything that has been stated from the dais, but there's a difference, and this is not the exact right phrase to use, but it's the thing that comes to mind the best for me. The appearance of impropriety. There is nothing that is improprietous from where I sit with where we are as a body and what we're trying to do in evaluating how to be fair. But do we really want to wrestle with the appearance of that, even in the lack of it? And as for me, my concern when it comes to spending an amount not to exceed $5,000 to ensure that this verification is done by an independent source, I just don't see an issue with it. I think that the benefit by far would outweigh the harm of doing it. And if I were to look at the amount of money that has been spent on litigation, both in terms of staff time and in terms of outside counsel, it would pale in comparison to the no more than $5,000 that we're discussing on the table tonight. And with what I read from this email that I've received, or we've received today, this is something that is coming from the chairman of the Board of Zoning Appeals. So he acknowledged that the city is not suing the BZA, as some people have said, so there is some rhetoric out there. I agree with that. But it would be a horrible thing to not go ahead and spend an amount not to exceed $5,000 and to have headlines all over the place. The city cries sour grapes because a decision was found by its BZA that is opposite what the council has decided, and as a result of it, we're not going to provide any legal help to the BZA in making sure that the record is properly transmitted. That's not a headline that I look forward to seeing. If, say, for spending no more than, an amount to exceed $5,000, we could stop.